All right, all right. We're here. It's another Wednesday, Water Cooler Wednesday. So we're here just for you guys to give you some great information. So it's me, Deanne Branch, EXP Realty, with my co-host, Lisa White, over that way.
I don't know
Yeah,
why.
get it.
Dion never know where I'm at. I don't know why.
I know, right?
Hey everybody, Lisa J, House Money Mama here. Happy Wednesday.
Yeah, yeah. And then today we have a special guest with us, Attorney Julie Jones, and she's going to talk to us about estate planning. So, um, some of you know, like I had my mom recently passed, my parents have passed, um, but we should be prepared. It shouldn't be something that we're like afterwards trying to figure out
Yeah.
what to do, how to do. We should take the time to be prepared. And so I want Attorney Jones to kind of help us to get us there. At least give us some 30 minutes on what we need to start, how to get
Yeah.
started with it.
Okay, well, thank you, Dion. It's good to see you ladies again. I love your energy. These water cooler Wednesdays are at the end of the day, but your infectious smiles and your energy pump me up and get me ready, even though I've probably been working a good 12 hours already. So what I is that the secret to getting pumped up?
Yeah, I'm gonna put it up there too today. It's
Um,
our water cooler Wednesday cups.
uh, oh, those are cool. I got to get one. I need some swag too.
Okay, yeah, we
But
got to get one,
so
Julie.
anyway, what I will tell you is, since I believe that this is, I don't know exactly who my audience is. Is my audience, is the audience for this mostly realtors? Who is the audience?
No, those they're just not realtors, they're
Our
consumers,
customers.
people,
Yeah.
Just
home
anybody. You
buyers.
guys just invite friends, family, anybody who wants information.
Yeah.
Okay,
Hmm.
well, but so what this is what I will start with. So first of all, just I thank you for welcoming me back. I was here a little while ago talking about reverse mortgages. And now I'm back talking about estate planning, and that those are two things that are near and dear to my heart. What I will say, just give people a 30-second background, not because it's important, because I want to show how important and accomplished I am, but it's important to know who you're talking to and how they know what they're talking about.
Yeah.
Yeah.
So I have been practicing law for about 26 years. You can see my shirt representing my law school today, Emory Law in Atlanta, and that's where I graduated from.
Whoop, whoop.
And so I was in corporate law. I mean, I was in corporate law for about 16 years, and I have had my own practice now for about 10 years, primarily focusing on real estate and estate planning. So again, this is in my wheelhouse. A little bit about how I started doing real estate is a segue to what we're going to talk about today. I did not do real estate when I first came out of corporate. I did estate planning, but most of you all can guess what people's largest portion of their estate is: real estate.
Real
That's the
estate.
biggest asset most people have in their estate. And so when I was doing estate planning, I kept telling people, but I don't do real estate. And they were like, but that's my estate. And I would try to refer them to other attorneys. And just like when people invite you in their family and you're an attorney, they expect you to do everything for them. So they
Yeah.
didn't want me to keep referring them out. So they made me learn real estate, which is now something that I do depending on what time of the year is. I do as much real estate as I do estate planning. So thank you to my clients who forced me into real estate. I enjoy it. I've already had six closings this week, and it's only Wednesday. So
Yeah.
that is why it's important
Awesome.
to start with real estate. Most of people have heard the ills or the perils of probate court. Probate court is kind of like the boogeyman, or kind of like Voldemort. If you are a Harry Potter fan like me, you don't want to
Right.
hear about probate court. It's like, ooh, it's something scary. Probate court can be expensive. It can be time consuming. And for me, sometimes it is a need to go to probate court. There are some special circumstances. But for the vast majority of us, if we plan in advance, as Dion talked about, we can avoid that expense in that time of going to probate court. Probate court is not always necessary. And if we can, we should try to avoid it. The
Okay.
number one thing that sends people to probate court here in Illinois is real estate.
Yeah.
If you have less than $100,000 in cash, there's a document that you can do that's called a small estate affidavit. Fill out some paperwork and get the money. It's amazing. If it's less than $100,000, that's considered a small estate. To me, that's not really all that small, but $100,000. But you can have a piece of real estate that's worth $5,000, little or nothing, and you still have to go to probate court for it. So real estate is very, very important. And real estate is the number one thing that I get phone calls about for people having to wind up in probate because their family did not do anything with real estate. The first thing I will say to you, I get this call probably at least 5 times a week. People will call and say, I need a quick claim deed. First of all, it's quit, Quit, not
Right.
quick. And there's nothing quick about it, especially in the city of Chicago. It's a quit claim deed, but they'll say, I need a quit claim deed. And as an attorney who's been doing this for 26 years, most people don't need a quit claim deed. So I have to ask a few more questions. Why do you need a quit claim deed? Well, my dad passed away and my sister and I want to get our name on his house, so we need a quit claim deed.
Well, it's too late at that
Too
point.
late.
There you go, ladies. You cannot put your name on anybody's real estate after they pass away without going through court. They have to do that. That's what we talk about. We not to get too deep into it, but we talk about the chain of title.
Yeah.
If you have a deed, I'm sorry, I'm trying to figure out this hair and
The
look at
other way.
There you
I'm trying to look at the camera. So what happens is when you have a deed, if Dion's name is on the deed, Dion's name needs to be on the very next deed. So if somebody gave, just to make it simple, if somebody gave Dion the property, the next deed needs to have Dion's name on it. If it can't have Dion's name on it, then we need to know why. And the judge will have to explain why Dion's name is not on it. So you can't just go get a deed and just replace your mom and dad and have an attorney, or go to the bookstore, not even get an attorney, go to the bookstore and draft up a deed that puts you and your sister's name on the property when your parents pass away. In general, if someone has not made arrangements for a deed to go in, a property to go into someone's name before they pass away, they're going to wind up in probate court. It's an unfortunate thing if their family wants to retain the property. So what do we do so we don't have to go to probate court, and so our family can have that real estate and be able to take care of it, whether it's mortgage, then they want to keep it, or whether it's mortgage and they want to sell it, whether it's not mortgage and they want to sell it or keep it. There's a couple things we can do. The first thing we can do is, in Illinois, there's a document called a transfer on death instrument, or we in the profession call it a TODI, TODI, TODI. So a TODI is like for lack of a better term, we call it a beneficiary deed. That's kind of a misnomer because a deed gives somebody a property now and the beneficiary gives it to them after you pass away. But basically, it's like adding a beneficiary to your real estate. And it basically says, when I pass away, I want Julie to have my home. So it says, I own my house now. And when I pass away, I want Julie to have it. As most people won't be surprised, Illinois was one of the last states to get this document because we're a little slow on most things. And it really is meant to make people have a simple way to transfer property without having to go to court, without having to engage an attorney to spend a lot of money. It is something that's supposed to be an inexpensive way to make sure that you transfer property. The recorder of deeds actually provides these documents. You can download them online. And that is something that will at least be able to get the property to the next generation. What I will tell you is an interesting fact that I found interesting when I started doing real estate. A lot of the properties in Chicago, a lot of you all have seen those properties in Chicago with those big red X's on them with the white signs. Most of those properties do not have mortgages on them, because if it had a mortgage on it, the mortgage company would have reclaimed that property and sold it. Most of those properties I've lost that don't have mortgages, but nobody can get title to the property. So either they just stay in it as long as they can and abandon it because they don't have the $3,000 to $5,000 sometimes that's necessary to go to probate court to transfer that property. Or there's missing heirs, or there's a relative that doesn't want to sign off on it. So for me, my heart breaks when I see those red X's, because for me, I'm thinking that's a house that probably was paid for, probably didn't have any debt on it, and now it's sitting there because of the fact probably that someone didn't take time to be able to transfer that property. Because typically a property that has a mortgage on it is not going to have a red X on it, Because trust me, the bank is going to come get that property and try to sell it for something.
Right.
So you can do that transfer on death instrument. What I will tell you about a transfer on death instrument is it is not as simple as it seems. First of all, that property should, a transfer on death instrument should really be used for a property that doesn't have a mortgage.
Okay.
If it doesn't have a mortgage, you can give it to whoever you want to give it to. So I don't have a mortgage on, I do have a mortgage on my house. But if I didn't have one, I could simply give that house to my daughter when I pass away because there's no third party involved. I own my house. There's no mortgage on it. A mortgage is a lien. There's no lien on the property. I can give it to her. But if I have a mortgage, I told y'all I do closing all the time. You can't just give away a property that has a mortgage on it because guess what? That property has a lien on it. That's what a mortgage is. And the mortgage company has some say about what you do with that property as long as you have a mortgage because it's their collateral.
Right.
So a transfer on death instrument is not the best thing to utilize if you have a mortgage because the lender's going to need to know who's going to pay that mortgage. And it's not just as simple as I own the property, now I own the mortgage. That's not how that works.
Okay.
So if you own the property outright and you want to get it to your family, you can use a transfer on death instrument. The other issue that comes up with a transfer on death instrument is it works pretty well if you only want to leave the property to one person. I have one daughter. I'm team one and done. So I have one daughter that's 27. So if I want to leave her my house, I just leave her my house because she's the only person I have. But I have 3 brothers. If my mother wants to leave us her house, she probably should not use a transfer on death instrument because some of you all realize the challenges of having more than one person on title. Some of those
Right.
houses with red X's, there's a brother who didn't want to sell. It's a sister who wasn't going to sign the papers. It's somebody we couldn't find who wasn't going to agree. So that's where you kind of need to sit down with an attorney and perhaps talk about some different strategies if you have more than one person that you want to benefit from a home. Because it gets complicated when you try to just slap 5 people's name on a house or even 2 people's name on a house and they can't agree about how to proceed.
Mm.
Don't even add the fact if some of them are married or not, if some of them have children and don't have children and all those things. But a transfer on death instrument really is better than nothing. It's better than a house sitting there with a red X on it. So it's not the best vehicle for all kinds of transfers, but it is something. It is something that you can utilize. So let's talk about, okay, I have a mortgage. So how do I transfer that property? Well, before I was an estate planning attorney, I thought you were supposed to have a will. I had a major surgery. Let's see, my daughter was about 12 and she's 27 now. So I would say that was 15 years ago. I did a will. That's what I thought you did if you wanted to make sure that your family had instructions about what was supposed to happen to your things when you pass away. What most people do not realize is here in Illinois, a will requires court. A will makes you go to probate court. A will is not valid unless a judge says it's valid. So when you have
Wow.
a will drawn up, what the first thing that an attorney has to do is go record that will within 30 days of your passing at the county which you passed away in or where you own real estate. And then they have to open a probate estate and they have to go in front of a judge and the judge has to review the will to make sure it's okay and all of that. So most people don't want a will because they don't want their family to have to go through court. But some people do the option of having a will. And again, that's better than doing nothing. Doing nothing is never typically that's not the answer.
Yes, right.
The answer is not to do anything. So a will is something that some people do. What do you do if you don't want to go to court, but you do want your family to receive what you have and you do want it to be an orderly transition? Most people do a living trust. So most middle income people who own real estate will have a living trust. Living trust has a couple of advantages. One, when you have a home and I do a real estate closing, there's 2 important things that happen with that real estate closing. The first thing that happens is you sign a note. A note is a promise to pay. So it is you telling your lender, I am going to pay this money back. The second thing that you have is a deed. They are 2 separate things. The deed says I own the property. So if you just put somebody on a quit claim deed or you just put them on a transfer on death instrument, you are saying that they own the property, but you're not doing anything with that note. The note doesn't have their name on it. When you pass away, it still has your name on it. Um,
Mm.
you will hear on the news, there's a person that's on the radio now that during the pandemic, they were having a advertisement, and it said, "Are you living in a house with somebody else's name on it? You know, that somebody passed away and you're living in the house and now you can't sell it and now you can't get homeowners insurance and you can't do any of those things." That's correct. Because just because your name is on the deed, if your name is not on that mortgage, if you have not assumed that note, then you have a house with somebody else's lien on it. So, how do
Mhm.
you take care of both ownership, which you can do with a transfer on death instrument, or you could do with a quitclaim deed, but also care for that mortgage? You have a trust, because a trust says, I want to give all of these things to my son, my daughter, my whoever, but also I want this person to be responsible for settling my debts. That is
Mhm.
the difference, because a trust says, I have named Julie as my trustee, and she's going to make sure whatever needs to happen with that mortgage happens. Does
Mhm.
it need to be transferred to my children because they're going to take over the house? Does it need to be paid off because we're going to list the property with one of these ladies and they're going to get it sold? But a
Right.
trust allows you to do both things. If you just put their name on the deed, a lot of those people still wind up in probate court and they don't understand. And they call me and they're very upset and they say, the bank won't even talk to me. And I own my mother's house because she added me to the deed. Or the bank won't even talk to me and I'm on a quitclaim deed. I don't understand that. And I say to them, the bank is not disputing you own the property, but the bank is saying they don't know that you're the person who's supposed to be responsible for this debt. You
Mhm.
might have a sister or brother who has a stake in this property as well. This some mortgages can't be transferred.
Right.
So that's a
Mhm.
I will give just a piece of something that's super important that I talk to about my estate planning clients about. Typically, an FHA mortgage can be transferred. So it can be assumed. So what
It's
that
an
means
assumed mortgage.
is what that means is if I have a mortgage and my mortgage is $1,000 a month and I leave my house to my daughter and she can afford the $1,000 and she can prove that to the lender, then they can have her sign documents that remove me from the mortgage and put her on the mortgage with the same terms I had. That's the
Mhm.
important thing about an assumption. Assumption puts you in the same shoes as the person who had the previous mortgage. That might be a benefit because the interest rate might be 10% or something when she
Right.
gets it. And my interest rate was only 3.75 or 3.25. If she
Mhm.
gets her own mortgage, she might have another 30 years. If she steps in my shoes, I might only have 12 years left. So an assumption is when that person literally takes over your mortgage, but only certain mortgages qualify for that. FHA mortgages usually qualify for that because the credit criteria is a little bit different. Also, I can't just assume anybody's mortgage. I can't say, hey, Dion's mortgage is pretty low. I want Dion's mortgage. Yeah, you have to have some sort of connection, and typically you have to be a spouse that lived in the property, or an adult child, or even a brother or sister, maybe. But you can't just come take somebody's mortgage because it seems nice and you just want their mortgage and not your mortgage.
Right.
So if you have a conventional mortgage, typically a conventional mortgage cannot be assumed. There's always exceptions. I want to make sure that, again, if you're trying to do any estate planning, you talk to your attorney so they get the facts of your particular loan. But the
Mhm.
issue that I have with people when they have a conventional mortgage, I tell them, if you leave this house to someone, they're going to have to be able to pay this mortgage off. Either they're going to have to be able to get their own money and just pay it off, or they're going to have to qualify for their own mortgage and get a mortgage to pay this mortgage off, because a conventional mortgage in general, it has a higher credit criteria. It's a little more stringent to get, and the
Right.
lender wants to have a full in-depth analysis of that person and approve them on their own right, not just let them take over your mortgage. So that's very important to know, whether your mortgage is FHA or conventional, because if you're trying to leave this house to your 25-year-old child who's just starting off working, they might have enough money to pay your FHA mortgage, but they may not have enough money to pay off a conventional mortgage.
Mhm.
They
So
may
I
not.
have a question for you,
Uh-huh.
Julie. Do you have to have the living? What if you didn't have the living trust? Could you still assume the FHA mortgage?
You could, but if you didn't have something, okay, so assuming the FHA mortgage, this is driving me crazy because
The other way, you gotta go the other way.
my
Right.
camera is backwards, so it's
Yeah,
making me do it the other way.
Right,
So
yeah.
I'm
I
just
know.
I'm gonna let this natural hair be natural and let it be free and stop looking at it. So the complication with a living trust is sometimes, okay, so let me take a giant step back, Dion, and that's a great question. Probate court, most people think probate court is about getting stuff to your family. They say, "Oh, I'm going to probate court because it's about distributing my assets." Actually, that's not how probate court originated. Probate court is creditor court. Creditors pushed for that all a long time ago because they said, "I know Julie is deceased. RIP. We so sorry for your loss, but Julie owes us
You
money."
still owe us.
And before
Right.
Julie gives her kids money and her husband money and all that, we need to find out who's going to pay us what she owes us. So that's actually what probate court is about. So when you go to probate court and somebody is named an administrator or an executor, yes, they're going to pass out what you left, but guess what they got to do first, Dion? Pay those debts. And they got to make arrangements with those creditors. So if that person does not have a will or they do not have a trust, if they don't have a trust, somebody has to be appointed the person to talk to the bank to even find out if the loan is assumable. And typically, if they have to do that, I'm going to look, I can see the questions coming in, so I'm going to grab that one.
Okay.
They typically, a living trust, we prevent you from having to go to probate to deal with the mortgage company or any creditors. Because when you set up a trust, you name a trustee and that person has been authorized by you to settle all your affairs. And part of settling your affairs is finding out what's going to happen with your mortgage. So the trustee has authority to call the mortgage company, produce the proper documents and say, "Hey, I'm working with Julie's daughter. She wants to retain this house. Mortgage company, let us know how that can happen." If all I did was put her name on the deed, she does not have any authority to talk to the mortgage company. And that's how she winds up in probate court, because that's the only way to get authority to talk to them if you didn't do a trust. So the benefit for the trust is not only are you saying where your assets are supposed to go when you pass away, but you're also saying who's supposed to take care of winding down payments and things for those assets. So that's the advantage of the trust.
Okay.
So somebody had a question in there. If the house is paid off and the parents don't have a will, will the house go to probate? Yes, it will. Because again, probate is not just about the creditors. Probate is about who is supposed to receive this asset. If they don't have a will, nobody knows who's supposed to receive that asset. So what happens is if you don't have a will and you go to probate, then the judge uses the probate statute, which is basically the next of kin statute. And then they look at your family. Somebody has to tell them who makes up your family. So if you have a house, let's use an example, a couple examples. You have a house and you have a spouse that's not on the deed and you have children. Then here in Cook County, here in Illinois, 50% ownership will go to your spouse and 50% ownership will go to your children. Whether you got one child or 10 children, they still get the same 50% and they have to divide it up. The judge cannot deviate from what that next of kin statute is. It is what it is. The problem that I get, another big problem that I get is a lot of times there's only one spouse on the deed for whatever reason. You know, I'm a lawyer. I don't want my name on any real estate in case somebody sues me. I'm a doctor. I don't want my name on the house. I got student loans. I got bad credit. We just want one spouse on the property. Well, the problem with that is the other spouse probably paid half of the deposit. They probably paid to take care of the house. And in their mind, their assumption, because people don't know probate code, is, well, if my spouse dies, I'm going to get this house. And they assume they're going to get the house 100%. They don't assume they're going to have to share it with the kids who never paid a mortgage, some of them never lived there. They didn't contribute to any down payment, and don't even get started if it's a blended family.
Oh yeah.
And now they got kids that don't even have any association really with you. They're your step kids. Now, I'm not picking on step kids because I was a step kid. Sometimes it's the biological kids that are the problem, because I don't want you to sell mama or daddy's house. This is the last memory I have of them. And you want to move. I don't want this house. I'm in this house by myself and now my spouse has passed away. This house has a whole lot of memories that I don't want to be here with. Or I came to Chicago because I was with my husband and now he's deceased. I want to sell this house and move back to Georgia where my family is. And now your kids are holding you hostage because they own 50% of the house and they don't want you to see your daddy or
They
mama.
want you to.
So the best way is so even if the house, to answer your question, even if it doesn't have a mortgage is just one reason why the house goes to probate. The other reason it goes to probate is because if you did not do a will, then you did not direct the rest of the world to who you want to have the house. And so if you didn't leave any directions, the court has to default to what what the law says. And the law would say, determine on whether you have kids, a spouse. If you don't have that, do you have parents? Do you have siblings? So that is why you go to probate court. Two things: who's supposed to pay your debts and who's supposed to get your stuff.
Okay.
Wow.
So a lot of people now. So for me, when I do estate planning, and everybody does things differently, I like to, what that the whole thing about KISS, keep it simple, stupid. So I try to keep things as basic as it needs to be. So if someone comes to me for estate planning, the first thing I'm going to ask them is, do you have real estate? If they have real estate, I'm trying to figure out how we can make them not have to wind up in probate court. Second thing I ask them is, do you have a mortgage? If they have a mortgage, now we have to go through another set of analysis about what we need to do. Third thing I ask them is, how many people do you want to benefit from this house? You just leaving it to one person and they could sell it, they could keep it or whatever? Are we gonna have a war of the roses type of situation where people are putting cords down the middle of the house and you live on this half and I live on this half, and all this kind of stuff, or somebody's not gonna sell and they're gonna hold out and all of this? So those are the important factors that would dictate what kind of estate planning you need, but you need some sort of estate planning.
So we talked a lot about real estate, Julie. What other things do people usually address? I know that's the biggest thing, so I'm glad you talked about that. But what are the other things that people normally address in estate planning?
Okay, so estate planning is comprehensive. So the first thing you do, and thank you for asking that question, estate planning is not just when you pass away either. So when I first started doing estate planning, I do a lot of educational seminars before COVID, but I've done some online stuff too, a lot of it. You have to re-educate people on what estate planning actually covers. The first part of estate planning is disability planning. So before you even talk about anybody passing away, healthcare power of attorney. Who can speak for me medically if I can't speak for myself? Property power of attorney. Who can take care of my non-medical affairs if I cannot speak for myself? Some states call that a financial power of attorney. Some people call it a durable power of attorney. But here in Illinois, it's called a property power of attorney.
Okay.
If I'm on life support, do I want to stay on life support forever, or do I want you to treat my pain and suffering and disconnect me? So that's a living will. HIPAA release. If I'm in a hospital, who can talk to doctors directly about what's going on with me and who needs to go through some other people? So when I start estate planning, when I do an analysis with people, and when I do my first introductory call, I start with disability planning. Because first of all, if you, there's a rule and there's a way to take care of my stuff when I pass away. And I don't want it to be overly complicated and I don't want it to be expensive. But at the end of the day, I'm not here. So it is what it is. But for disability planning, I am still here. So it's very important that these things are taken care of in a timely fashion. It's very important that these things are taken care of in a way that's not expensive for my friends and family, because I'm still here. So I need to make sure that somebody can talk to the doctor without going to court, because that kind of delay, that kind of expense might impact the treatment and care that I receive.
Right. And I think I'm sorry, Julie, but I think a lot of times, a lot of people are like, I don't want to talk about estate planning or anything because I'm not dead yet. So, while we're trying to get our parents or somebody to talk about estate planning, maybe start with saying, let's talk about how we're going to care for you.
Absolutely. That's how I start. And when I first start my conversation, I never start talking about people's stuff. So it depends on how they come to me. Sometimes people will come to me and I ask them, why did you call an estate planning attorney? And they may say, because my mom and them house was caught up in probate forever. And then I know what their mind is on. But my conversation starts with disability planning. When I used to go in person with people, I would start off with, when I first transitioned out of corporate law to estate planning, the biggest thing was to get people to understand they had an estate. because estate, we think of something like the Carringtons on, Dynasty or something like
Yeah,
Yeah.
that.
right,
Or,
right.
or the Lions on
Right.
what is the name of that?
Power.
with,
Your
with
power.
Cookie and
Right.
Lucius.
Right.
They say I don't have any estate. And I said everybody has an estate. And so I would tell people to put their hand on their heart. I say, you feel that? That's your estate. Whether you're in a
Mhm.
nursing home and you don't own real estate anymore, whether you're a 21-year-old and you just went to college and you ain't got nothing but your mama's credit card that she gave you and some old furniture. Empire. Thank you. I couldn't think of
Right.
the name of it.
Yeah.
I should, since Josie is in court, I should be thinking of Empire. But anyway, your estate is you. And so I tell people, a lot of people, to Dion's point, a lot of my older clients, I don't care what they get anyway. I want them to go to court and fight or, spend their money over it. I'm not going, or the people act like people going to kill them to get their stuff. Most of us don't have enough stuff for people to kill us to get it. So you don't need to worry about that. They're not going to kill you to get that little house that you got over there.
Right,
It's fine. And
right.
so when they start with that, I said, but it's not about getting your stuff. It's about who is going to take care of you if something happens to you. And you want to make sure that they're able to take care of you in the way that they need to without having to go to court and without having to spend money to be able to do that. If you don't have paperwork in place for your disability, your family's going to have to go to probate court as well. They're going to have to go to a different part called guardianship court.
Wow.
And guardianship court, you have to give reports about how much money you spent on somebody. If you spent a money for them to go on vacation, the judge needs to see. Sometimes the judge has to approve that, even if it's your spouse and you're spending their money sending them on vacation. Sometimes people get in guardianship court and argue why they paying for a cable bill out of their money. They got dementia. They don't know anything about it. It gets down to that level of detail because everything
Wow.
that you do is under court supervision and the judge needs to know about it. So
Mhm.
why have that? I've seen spouses have to go to court to be able to take care of their spouse, which is something they think they can do automatically. Here in the state of Illinois, nobody speaks for you if you're over the age of 18 unless you put something in writing.
Wow.
So even if it's your spouse, even if it's your adult parent, if it's your adult children, even if it's your parents, they do not speak for you if you're over the age of 18. And people don't realize that. So when I used to go to those seminars, when people are going college send-offs, and I would ask the kids, if you got sick at college, who will speak for you? And they would say their parents. And I say, not if you're over 18 and you don't have paperwork. But I'm on their I'm on their healthcare insurance, and they pay my bills. Some of us have experienced that when our kids have been 18 and they're still in high school before they graduate. You can't really get information because they're 18.
Yeah. I
Same
think
thing when I go to the nursing home or go to a assisted living, and I talk to the seniors and I say, who would speak for you if something happened? They would say, well, my daughter would, or my son. Not if you don't have paperwork in place. They would have to go to court to get permission to do that. Same thing with your spouse. When I go to marriage retreats and everybody's in love and they making starry eyes at their spouse, and I say, who would speak for you? My loving spouse. No, they would not. No, they would not. Not under Illinois law. If they want to speak for you, they're going to have to go to guardianship court unless you put paperwork in place. So
Wow.
to answer your question, estate planning starts before real estate. I just talked about that just to kind of jump into this, but it starts with
right.
disability planning. And what I tell people is, if you don't plan for your disability, you may not have anything to leave anybody in the first place.
Mm.
Right.
Because if you got a house and you disabled and nobody can pay the mortgage and nobody can talk to the mortgage company, you might not have that house very long. If you got money, but people have to use it to go to guardianship court to get able to take care of you, now you're dwindling down in the estate that you might leave because they had to use that to be able to take care of you.
You're always so insightful. Oh my goodness. I
Yeah.
learn something every time I talk to you. Seriously.
Well, thank you, because it's a lot. It's a lot of stuff that we just don't know.
Right. Yeah.
Mm-hmm.
And
Right.
I know
Right.
that we only have time for a little tidbit here to let people know that they need to know more, because there's
Right.
much
Right.
more to this. So this
There's
is not meant to be your legal representation for the day. This is meant to be a teaser to let you know that there's a lot more to come. I have done whole day estate planning presentations. So this is just to wet your whistle, and
right.
hopefully you've heard something that you said, wow, I didn't know that. I might need to talk to an attorney and get more information.
Yeah. Yeah.
Yeah.
And
Yeah.
that's really what it is. We want to come to the water cooler. We want to share some information for you, and it's for you to take action. on that information that we're sharing, because we
Yeah.
care about you guys out here. And
Mhm.
so Julie's phone number is here. If you want to get in touch with her, she'll definitely talk to you about estate planning for you or for your parents. Here's her email address. You want to take it down real quick and shoot her an email. She's always available, except when she's handling my deals. But
That's right. Then I got to focus on what I'm focusing on. Somebody said they have a question, but I don't know if they'll be having a chance to get it in, so they might have to just give me a call.
oh, okay.
Yeah.
Garen, you want to give that question real quick, or
Yep,
is it
if
a
you
quick
got
one?
time, I got time.
Right,
Garen might be typing.
right.
Probably. Garen has been pretty engaged this whole time. So
Right.
Oh, oh,
Uh-uh.
I don't know. Tom Vaughn. Do I know Tom? Did I know Tom Vaughn? The name sounds familiar, but I don't know if I know Tom Vaughn.
Okay. All right. And then
all
we
right.
also got okay, somebody be ready to talk to you soon, Lisa. So
Hey,
Right, Lisa? They ready for you, girl.
right.
I'm ready. I'm ready.
All right.
Oh, I think
So,
yes, I do know. I do know Tom Vaughn. Now that I thought about it, I was like, but not Tom Vaughn. I think I know Tom Vaughn is Thomas Vaughn.
Okay.
mhm. Yep,
Oh,
yep.
and they somebody asked for the email again. It's
Thank you.
Okay.
Julie A at julieajoneslaw.com.
All
There it
right.
is.
Thank
Yep.
you.
Okay. Yes.
And so next week, actually, we'll be talking about some updates and changes coming from year 2022.
Yes.
We're gonna
Yes.
have to have
So
you back too again, Miss Julie.
What's the update? You said updates on the year 2022.
Yeah,
mhm.
just things in the industry, in the real estate industry.
Oh,
Like,
real estate. You didn't say, and I was like,
mhm,
remember I said, is the call all real estate? Yeah, lots of stuff. Every year, people to chime in that every year, 2020, every year, all this new stuff rolls out in January that people don't know about.
right.
Yes, I do know who Thomas Vaughn is. I had to deal with him, so that makes sense. Because when people call people by their abbreviated names and stuff, I'm like, no, not
Not
Thomas,
always true.
Thomas
Right.
Vaughn. That's how
Yep.
I know
Yep.
him.
Yep.
All right.
So
Well,
yeah.
everyone, it was a pleasure. It's always a pleasure talking to you guys,
Always.
giving out information. I love keeping our people informed. Please
Thank
feel free to
you.
reach out to the office and email or call us. And
Mhm.
if you haven't already done something, please get your estate planning in order. Don't make GoFundMe be your estate plan, please. Don't make
Right.
the probate court be your estate plan. Take control of your own information and how you want to make your transition and how so you are able to transition in dignity, is what we
Yeah.
say.
Yeah.
Yeah.
Yeah. Yeah.
Thanks, Miss Julie.
It's
Right.
nice to see you, ladies.
Right.
Everybody have a wonderful holiday and be
You
safe.
too. You
Right.
too.
Thanks.
Thank
Bye
you.
Thank
bye.
you.
Have a good
Thanks,
night.
everyone.
All right.